Hey there, welcome to yet another video in this series. In this session, we will go over various use cases of infringement and not so infringement in light of the provisions available in the Patents Act. As we know, Section 48 provides a patentee several rights with regards to its invention. But Section 47 and 49 talks about few use cases and situations which defines what actions cannot be considered as infringing actions even when the invention was used without the permission of the patentee. So you will be provided with various use cases or questions which would weave a story around you and ask you to understand the situation and advise your client, who could be the patentee or the potential alleged infringer, of how to go about dealing with the case. Now, to help you visualize such a scenario, let's go over a use case. Again, a big one because story needs to be told. Brahma is a retired naval officer in Chennai. After his retirement, he set up his own lab for research and development. He developed an ultrasonic device which can identify dolphins. This device, if attached to the large fishing nets, can identify if a dolphin is entrapped, and the same can be released by the fishing vessels by a release mechanism in the net. So novel. As dolphins are also a protected species, this invention has a great potential for commercial interest. He applied for a patent and received it in 40 countries in January 2009. Amazing. In December 2009, he came to know that a fishing vessel from Lemuria is another country, was fishing in Indian territorial waters and was confiscated by the Indian Navy and brought to Chennai port. Okay. The captain of the vessel pleaded that they lost their way due to failure of their navigation direction software, underline this, and thus entered the territorial water, temporarily, accidentally. The Lemurian embassy at Delhi had taken up their case. He also learned that they used fishing nets which contained his patented ultrasonic device made in country Lemuria. Lemuria is a new nation state, does not have any patent laws and are in the process of preparing one. Of course, Brahma approaches you to consult whether he can file a suit of infringement on the company owing the vessel for infringing the patent. Based on the above facts, you are required to prepare a consultation note to your client based on the relevant provisions of the Indian Patent Act. See, this is very subjective case. While I am reading it, I can think of multiple ways of justifying from both parties' point of view. But see, they have so nicely disclosed everything. They are making you think from Section 49 point of view, where a foreign vessel, which is temporary or accidentally, is in Indian waters and is found to be using patented invention for its own use, for the working of the vessel itself, is not considered a infringing act. But this also needs to be substantiated by how the invention was working, was it required for the working of the vessel itself, and also whether the country, Lemuria in this case, provides similar rights to the Indian residents or not. So this answer needs to be looked into two points of view, under Section 49 only, and then provide your opinion on why this is infringement or not infringement. So this is how an infringement related use case look like. So how do we decode the question? So to start with, we need to understand the situation that led to the infringement. Can the infringing activity be considered as a reasonable trial, or was it done for commercial gain? Was it for educational research purpose? Was it for government purpose or for government? Was it done through parallel import, Section 107? Was it on a foreign vessel, or was it to generate research and development data that needs to be submitted to another government authority? Bular provision 107, 107A again. So these details usually would be provided in the question itself. And if it is not provided, this should be your questions. This should be your assumptions that you need to mention while asking your client or while responding to the answer. While you do so, your client could be the infringer or the client could be patentee. So you should be thinking from both the perspectives, or from your client's perspective, who could be infringer. In that case, he would say, do I infringe? Or from the patentee, in that case, he would say, can I sue the other guy? Now, after we have gathered such information from the question, we will begin coding our answer. And how do we do it? By mentioning our understanding of the situation. How do we do so? As per the information disclosed, the party A was availing of the patented product for the purpose of this. Now, this purpose could be the purpose that we identified in the previous slide, or this purpose could be directly, selling, using, or offering to sell kind of, or importing, right? Now, depending on the objective and who your client is, you will pick and choose sections to either justify the actions of your client or justify the actions to be infringing actions so that your client can sue the infringers. You will mention the section numbers to complete your concluding remarks. Therefore, in accordance with the section 48, which defines the rights that you have, or 47, 49, 107 that defines the non-infringing activities, the action is construed as an infringing activity or a non-infringing activity based on who your client is. Now, because you have quoted these sections, you need to describe these sections in details to justify the actions as per the sections. Pick the details from the question itself, that this action was done for this purpose, hence this is infringing because this is not provided as per section 47 or 49, or this is non-infringing because this is as per section 47 and 49. Now, depending on what your concluding remarks were and how much more details are required in the question, you can go on and talk about infringement sections also, 104 onwards, both from the point of view of infringer, which is section 106, and patentee, which is section 104 and section 104A. So we have learned how do we decode the question and how do we code the answer. Are we ready to take on few use cases now? Let's get going. A ship registered in Panama and operated by white water lines from Brunei accidentally entered the territorial waters of India in the Bay of Bengal. See, a ship, Panama, and accidentally. There are three keywords which should hint that section 49 is in full application here. The Indian Coast Guard confiscated the ship and brought it to the Chennai port. Upon inspection, it was found that the ship had an underwater exploration robot arm for its actual needs. This is one of the qualifying criteria. The said equipment contains many features that are claimed in a patent granted to IMU. IMU files an infringement case against the owners of the vessel. White Water Lines approaches you for advice. Draft a notice for your client suitably advising him in accordance with the provision of it. If you decode the question, there are keywords that you can pick. A ship registered in Panama, foreign vessel, accidentally entered the territorial waters using the invention for its actual needs. So section 49 clearly tells you out that this could be one of the cases where it may not be considered as an infringing activity, provided, which I'm not sure of right now, that Panama also provides similar rights to the Indian resident. If that is the case, we can advise White Water Lines that this is not an infringing activity. You can respond to IMU accordingly. Moving on to the next one. Salim holds a patent on an agriculture tool in India and in the US. Salim authorizes Bharat to produce and sell the patented tool in the US. Julie buys the agriculture tool from Bharat and imports to India. Will Julie be liable for infringement in India? Explain. Very beautiful case. Salim has patent in India and US. Salim has authorizes Bharat. So Bharat is a good guy. Bharat can and has the authority to sell the tool to anybody he wishes to in the US. Julie bought it from the US and then imported to India. All this is allowed as part of section 107A. So you can mention your understanding of what has happened, and finally you can invoke section 107, justify the series of events in accordance with the wordings of section 107 or qualifying remarks on section 107. So this brings us to the end of this session. Just to recap, we discussed use cases how to decode the questions to gather details about the infringement and the circumstances that led to the so-called infringement, and then applied sections 47, 48, 49, 104, 106, 107 to either prove the infringement or justify the actions as allowed actions. I hope the coding of answer that we discussed would help you to create some sort of framework for you to write or code the answer while you address the situation that is presented in front of you. In the next video, we will discuss few more use cases. So I'll see you in the next one. Till then, be good and take care.